Thank you, Deputy Speaker. I would like to make a few points. First, the government has been always very clear and upfront on the policy objectives of this highest-triggered reserved elections framework. It has been 46 years since we have had a Malay president, and our challenge was how to achieve both meritocracy and multiracialism, where qualified candidates from different races can regularly be elected to be our head of state. When the Prime Minister announced the appointment of the Constitutional Commission to review the elected presidency system, he said, our president is the head of state. He represents all Singaporeans in our multiracial society. As such, it is important that the minorities have a chance to be elected and that this happens regularly. Second, the government has always been clear that when it comes to the counting, it is a policy matter for Parliament to decide, and Muslim protests far too much. I made this clear up front. In a dialogue session held after the government released its white paper, I was asked the following question: when would the circuit breaker to hold a reserved election after a racial group has not been represented in presidential office after 5 continuous terms come into effect? What was my reply? The most direct answer is actually the government can decide. When we put in the bill, we can say we wanted to start from this period. It is a policy decision. The CNA reported it. It is still on record. The Court of Appeal has confirmed that it was for Parliament to decide. Ms. Lim says she was present. She heard this judge ask that question. That was said. This was said. Why didn't you read the judgment? There is only one person in this House whom the courts have held to be misleading Parliament, and he is not from the PAP. Only one person. After evidence is held, Ms. Lim knows whom the High Courts held was misleading Parliament. So I suppose Ms. Lim knows all about misleading Parliament. The Court of Appeal's judgment makes clear a number of things. First, the constitutional text is clear that Parliament can choose from any of the 5 terms preceding the 2017 elections. Second, the PM's speech in Parliament on the constitutional amendments made it clear that Parliament intended to give itself the discretion to specify the last term of President Wee as the first term to be counted for purposes of deciding whether an election is reserved. Members can read the part Ms. Lim quoted from the Prime Minister. I don't see anything that's ambiguous. The point is this, and we are not changing history here. Ms. Lim is a lawyer, she knows this. Dr. Wee, in the second term, exercised the powers of an elected president. There is nothing ambiguous about that. That's a matter of clear law. Parliament could have started counting from Dr. Wee. It could have started counting from an earlier president. Parliament decided to start from Dr. Wee. It was made very clear, and it was made very clear as a policy decision. But in the context of that, for example, if we wanted to start from Dr. Wee, are there any legal impediments to start counting from Dr. Wee? I'm just talking about one question amongst many that can arise. There are a number of questions that can be asked, and there were also provisions relating to minority rights and so on. And I said that we are asking AGC to advise on a number of questions. That was on the, I think it's on the CNA transcript. So the Prime Minister was entirely right to say, we will start counting from here. The next elections will be reserved for a Malay president. And we have taken advice from AGC. What Ms. Lim is saying is that we are starting to count from here because of AGC's advice. And that was never suggested. We start counting, we are a careful government, we make a policy decision, but we take advice to see whether there are any impediments. And this government, as a rule, generally does not publish legal opinions that it gets. If it can be done according to the law, we do it. If the law has to be changed to achieve policy objectives, we do it. And I said it up front, well before the parliamentary proceedings. And the Prime Minister was totally clear. And the Court of Appeal said the Prime Minister was very clear. What Mr. Kumar said in court is, you don't try and take every MP's speech and every minister's speech and then try and interpret it as if it's a statutory interpretation. You go back to the legislation. And we had a long spiel, totally irrelevant, about a Queen's Counsel advice. Ms. Lim knows what happened to the Queen's Counsel advice in court. She carefully omits saying anything about that. And we know how QC advices can be obtained. What matters is what the Court of Appeal has said. And the Court of Appeal has been very clear. They said the Prime Minister has been very clear. They looked at the proceedings. They looked at the legislation. This argument that it was unconstitutional doesn't have any leg to stand on, because the Constitution provided for Parliament to legislate, and Parliament legislated. Nobody is suggesting that Dr. V was elected. It is an untruth that's attributed to the proceedings. What is suggested that he was the first person to exercise the powers of an elected president. And is there any legal impediment for us to start counting from there? And these are questions which others may just decide for themselves, but we will usually ask AGC for advice on these things. And that's exactly what, if you look at the context, we decide and we check with AGC. Prime Minister said it, DPMTO second day said it, and Minister Chan said it a few months later. The Court of Appeal, as a matter of law, said AGC's advice is irrelevant. Attorney General's chambers also argued in Parliament, in court, that their advice is irrelevant. Absolutely so, because for the legal question of whether a provision is unconstitutional or constitutional, and Ms. Lim really should know about this instead of spending so much time making a point out of nothing. The question before the court is, this particular provision in the Parliamentary or Presidential Elections Act, is that constitutional or unconstitutional? What does the court have to do? The court has got to look at the constitutional provisions. It's got to look at the provisions in the legislation. It can have a reference to parliamentary debates if the provisions are not clear, and decide how it interprets, which is what the Court of Appeal did. And in that context, what one party, the government's lawyers, told the government, or what the other party's lawyers told the other party, Dr. Tan Cheng Bock, are completely irrelevant. And that's a legal argument AGC put forward, and that is a point that the Court of Appeal also makes. But that's quite different from the Prime Minister in Parliament explaining that, look, these are the steps we have taken. We have also taken AGC's advice. He is telling that to the members. It's the truth, but it's irrelevant as a matter of law. Surely you know the difference. Let me therefore summarize and say this, sir, Mr. Deputy Speaker. The government made it clear right from the time when the Prime Minister issued instructions in terms of within Cabinet, and then set out a letter explaining what he wanted to do, the terms of reference, and then when the Constitutional Commission was set up, he also explained to the public that having a minority representation is an important issue, and he wants the Constitutional Commission to consider that issue, amongst other issues. Then we have the Constitutional Commission's report. The government made clear in the white paper exactly what its approach was, including on the reserved elections. And then we explained it on the ground, district by district. And I said on record, and I'm happy to be shown any other part. Muslims suggest that I said something else somewhere else. That is quite untrue. I am very clear and careful about what I say, and I'm happy to be confronted with anything else I might have said. I said this is a policy matter for us to decide. And we are taking advice on a number of issues. I mean, I'm paraphrasing because I don't have it in front of me. Why would I go and say it's a policy matter if I thought it was a pure legal issue? So if Muslim is right, then I was misleading all of Singapore.
Mr. Shanmugam, you've got 30 seconds.
Thank you, sir. I will use up the 30 seconds and sit down. So we were very clear. It's a policy matter, and that is on the record. Prime Minister took the same position. He explained in Parliament. We decide, but we took AGC's advice. And the next day, DPMTO and subsequently Minister Chan took the same positions. Did anyone say, we are going to decide this way because this is the way that AGC has told us that we have to decide? I mean, that would make no sense because Parliament is sovereign. Muslim must know Parliament is sovereign. If that's a certain legal provision, we can change the law. But, you know, in context, you've got to read whatever statements are made. In the overall context, Parliament is sovereign, its will is sovereign, and the real issue is, can we achieve what we want within the current framework of taking this approach, or do we need to make some changes? I think it's quite clear. Thank you, sir.
Order. The time allowed for the proceedings has expired. I adjourn the House.
Can I please read the Prime Minister's, what the Prime Minister actually said and put it on record?
30 seconds.
Yes. We have taken the Attorney General's advice, and we will start counting from the first president who exercised the powers of the elected president. So no rewriting of history here. That was Mr. Wee Kim Wee. That means we are now in the 5th term of the elected presidency. We will also have to define the race of each of the elected presidents we have had so far. There is no practical doubt, but as a legal matter, we have to define it. Thank you, sir.